Each of us must confront our own fears, must come face to face with them. How we handle our fears will determine where we go with the rest of our lives. Judy Bloom.
Welcome to the Simply Retirement Podcast with your host, Eric Blake. I'm Wendy McConnell. Judy Bloom, the author.
That's right. Yes. Talking about fear. That's one of those, when it comes to money, unfortunately, fear often plays way too big a role. And it's going to be the case today as in the topic we're going to be discussing.
Okay. Well, I've given up not getting over my fear of Ferris wheels. I have just retired from them. But when it comes to money, yes, we have to face those fears.
Well, one of those topics that many people fear is estate planning. That's what we're going to be talking about today because, nobody wants to talk about it except for attorneys and financial planners, of course, or at least your financial planner should be talking about it. If they're not, you might need to have a conversation with them about why they're not asking you about it. But in my experience, it's been one of those topics that people just, whether it's the lack of understanding or it's the, coming to grips with, hey, my mortality, I am going to be gone one day. Whatever it is, it's just one of those topics that people like to avoid. But the other thing I'll say is it's one of those that once it's done, there's almost like this weight that's lifted off your shoulders. I finally got it done. It's off my plate. I don't have to worry about it anymore. Actually, what's kind of interesting. I had a client that has been with me almost since day one of my career, almost 24 years. They've been a client. They finally got it after all these years of bugging me or me bugging them. They finally got it done. And it was just like this weight was just lifted off. When you post on Facebook your big estate planning binder, like it's this big life event, it's important. And they finally got it done. That's like it
Yay.
was. Like they had to take a break. I think the wife said, I just got to take a break. I'm going to take a break from Facebook now after we got our estate plan done. I'm like, it took you all this time and you feel so good about it. You're just going to drop Facebook for a while. That makes sense.
All right. So we have somebody here with us today to help weed through some of these questions, right?
Absolutely. Today, we're going to be joined by Chris Downs. She is an estate planning attorney with Krupa Downs Law. And one of the reasons I wanted to have Chris on the podcast is that she is very big into education. If you see any of her content on social media, LinkedIn, Instagram, there's a lot of education involved in what she puts out there. And I really wanted to have her help us in understanding some of the basics of estate planning and hopefully remove some of that fear and hesitancy that many people, but especially our audience being primarily women, to just have that fear about estate planning and how can we move forward and make sure we get some of these key documents in place. So Chris Downs, welcome to the Simply Retirement Podcast.
Eric, thank you so much for having me. I'm looking forward to our conversation today.
Absolutely. Well, and like I said, I think one of the reasons that so many women are hesitant, and again, people in general, is because of that lack of understanding. What is an estate plan really? And, besides, again, the acknowledgement of their own mortality, but many only think about the case when you die, not realizing that the estate plan really, and maybe more impactful or more important while you're still alive. So if it's okay, can you just give me what's a basic definition of estate plan, or what does it mean to have an estate plan?
Oh my goodness. When I think of an estate plan for people, and I share this out there, I think of a word cloud. Anyone familiar with the word cloud, where it's just all these words that are put out
Right.
on a sheet of paper? They're all randomized, but there's usually a common theme behind them. And that word cloud for me is throwing out the words like retirement accounts, houses, cars, jewelry, a vacation home, my art collection, pets, unfortunately, are personal property, but it's all this stuff because we actually all have property. So we all have some stuff that we need to consider what will happen to it when we do pass away. And part of estate planning is figuring that out. So it's figuring out the who gets it, the how they get it, the when they get it. And it also tacks on there the notion of I can provide some incapacity planning for myself with some additional documents or the use of a trust that would say, hey, you know what? I might be here another 20, 30 years, but what happens if I'm really not okay and I need someone to manage that estate for me? So that's just generally what I would say about estate planning.
Perfect. Well, and if you don't mind, I would like to just take a quick step back. And, people get into different forms of the law, and they're usually driven by something inspires them. So just from your perspective, how did you get into what drew you to estate planning in the first place?
The need to help people. I'm a second career attorney. I had a first career doing other things for a company, and I loved that. I loved everything about it. But one day I was faced with the decision that a lot of people are, and women, to where you say, is this still the right path for me? Do I need to make a shift in my career? And what would that look like? And for me, that shift was asking the question, if I could do anything that I'd wanted to do, what would that be? And the answer was go to law school. So I did do that with the support of family and my now husband. And as I was in law school, I kind of, Eric, knew the things I didn't want to do being a lawyer. I didn't want to be a trial attorney. I didn't want to be in litigation. And it was just naturally through taking classes for estates and trusts and federal taxation that I thought, I have an affinity for this. This makes sense to me. And it also allows me the ability to just help people, to help them go, it's okay. You know what? We can step through this together and do the plan together, do the documents together. And I just felt like it was what I was being called to do, was just be a helper.
Awesome. And that and that's where I hear a lot, the theme of being able to help people. But again, one of the things I really value about, us having some connection is that education aspect. I've had the opportunity to refer a couple of clients to you, and that's what they come back to me every time is she took the time to help me understand what I needed to do, what direction I needed to go. And that's such a valuable skill especially when it comes to estate planning, but anything with the law, but definitely estate planning.
Thank you for that. Did they tell you about my illustrative devices where I like to use pens and pen cups to illustrate for particular concepts?
Hey, visuals are almost always the best route to go. I mean, when you just talk about it, it's one thing, but when you can actually illustrate it and actually put put it down where people can visualize the concept, it can really make a huge difference.
I agree.
So let's start, just go again, some of the basics, because we know estate planning is important for everybody, but, think about estate planning. Why is it so important, particularly for single women? Maybe if they've gone through a divorce or been widowed or just single by choice. Why is having an estate plan so important?
Well, I think it's important for single women through any of those chapters in their lives to consider having it done, because I think that we have to answer the tough questions and get them out of the way. So if we're not able to take care of ourselves and make decisions, who are our trusted individuals that we want to step in and do that for us? And I know we're going to step through various documents, so I'm not going to go too much deeper right there. It's also about peace of mind, if you will. So knowing that when I'm not here anymore, I have set up for success the individual or individuals, or maybe a charity that I want to benefit from my hard work and effort. And if we kind of pull in and tug the thread a little bit about divorce, what's really important for that is that when we go through a divorce, the law does naturally end some of the beneficiaries that we list as our spouse on there. But I think it's important that we actually physically revisit that through an updated plan and make sure that we don't inadvertently leave our ex-spouse as a beneficiary on our employer retirement account. That we consider that if we have children from that marriage, that we set up the proper plan for them when we're gone, because maybe we don't want our ex-spouse to take control of the money that we leave for our children. And so I feel like it's just that sense of, it's a weird way to put it, but it's almost like tying a bow on it, if you will, to say, look, this is something I need to do. Let's get it done. Let's tie the bow on it and say, we've got it taken care of.
Perfect. And as you look at, again, the important, and as you said, we'll talk about some of these key documents here in a little bit and how do you actually go about accomplishing some of these things. But can you just touch on a little bit about the importance of having estate plans before you actually die, while you're still alive?
Oh, absolutely. So if we don't do our own estate planning before we die, we will die intestate, which means we die without a will. And Texas has written a will for each and every one of us, and it will define who our heirs are when we die. And those heirs may not be who we intend them to be or who we want them to be. So I'm going to give you an example. If I'm a single woman, let's go down our theme of being single. I'm a single woman. And let's say that I was not blessed with children or grandchildren and I'm single. My heirs would be my mom and my dad if they're still alive. If my mom and dad are not still alive, it would be my siblings and nieces and nephews. But if we think about life circumstances and different types of nuclear families, I might not have my parents alive anymore. I might be an only child. I might have siblings I don't care for. I might not have nieces and nephews. So we have to think through that. If all of that generation is gone, it can go back up to my family tree on my maternal side and paternal side and begin looking for living relatives and cousins that would inherit from me. And I may not actually want that, Eric. I might be that woman out there that's like, I have worked hard to build what I have in my life and what I have done. And yes, I might have family, but maybe I'm more wanting to leave it to a lifelong friend. I'm leaving it to a charity, leaving it to a donor advised fund or something that I'm working with my financial advisor for to do give back over future generations. So if we think about that stuff now, as hard as it is, we're building up something that will live beyond us with love and making it easier as well. That's the other thing that everyone needs to know. When you die without a will, it is very hard. The probate process becomes more complicated. It becomes more expensive. It can add more heartbreak to families who are already grieving the loss of a loved one. So it's always better just to take the time and let's just get it done and not have to have the unanswered questions later.
Perfect. So let's go and move forward with getting some of these key documents defined, what they are, how they work, and some of the key decision points. So again, we'll use the single woman concept and say, hey, they've gotten past that fear of getting their estate plan done and that we're ready to start taking action. First thing normally is going to be a will. But again, just understanding if you can help us define what is a will, what are some of the key decisions that need to be made as you are putting that will together?
Okay. So a will is our opportunity to say who gets our property when we die, how they get it when we die, maybe when they get it after we die, and who's in charge of making that happen. So let's break down those four kind of roles, components, if you will. So the who I think is relatively straightforward, right? So I'm a single woman and let's build on that. Let's build a history for our single woman here. So she has one sibling and she has a couple of nieces and nephews. Mom and dad are gone. We have a tight-knit family situation here. And she's like, you know what? When something happens to me, I just want everything to go to my sister. And if she's not here, I want it to go to my nieces and nephews. So that's the who. The who gets our property when we die. The how they get it encompasses the notion of, do they get it outright? Meaning I just write a will and everything goes to my sister outright with no contingencies on it, no trust surrounding it. I'll explain that in a little bit in a moment. The when they get it is a component of how, in the sense that, let's say my sister's not here and now it's going to a niece and a nephew. They might be minor children and minors cannot control property until they're 18. So I can actually build in that will the thought that, yes, it's going to go to them, but we're going to put it in a trust for them until they reach 25, for example. And then that brings in the who's going to do the role component of who's going to make this happen, who's going to probate my will with any attorney, who's going to be the trustee if a trust is created through my will. And really, that's what a will does, is it's our ability to say those things. And hey, by the way, a will can do a lot more than that. If we have a taxable estate, it can have provisions in there to how to address estate tax consequences, which a lot of us will not have right now with the exemptions being as high as they are. But things like that can also happen in wills. And it's really our way to answer those questions.
And just thinking about, you talked about the concept of a trust. So what type of trust might be included in a will that would help make some of those decisions a little bit easier on how those assets may be transferred in a way that benefits, again, a minor child?
Oh, I love that question. So usually it's a contingent trust in a will that is going to do that. I always like to use the visual, it's hard to visualize it right now on a podcast, of a light switch. So my will can contain a light switch in it that says, If I have a beneficiary that is under the age of 25, the light will turn on for them and the assets will go to trust for their benefit with a trustee who would manage it and control it and would be able to make distributions for the beneficiary's health, their education, their maintenance, and their support. So if we think niece and nephew, and Eric, I'm going to make you my trustee in this example, is you're the trustee of my nieces and nephews' funds because I'm gone. You're able to look at their life and what's going on with them, help them maybe buy that car because it's time to drive, help pay for college if they love sports and they play select soccer, for example, funding the cleats and the uniforms as they continue to grow. And you're doing all of that through the lens of a fiduciary. So you're doing it for their benefit and you're trying to also protect the money and let it grow so it just doesn't get flushed away. And so that's a contingent trust that I think every will happens when we're talking about leaving things to either our children or grandchildren or nieces and nephews. The other type of trust that wills can have in it is we can include something called a disclaimer bypass trust in a will. This is a federal estate tax exemption trust to where if I did die with a taxable estate, and I needed some of it to circumvent, it usually works best for spouses, to circumvent inclusion in my spouse's estate for estate tax purposes. My spouse can disclaim part of my assets into a bypass trust and then minimize estate tax for him. The other type of trust that I want to mention that we often as estate planning attorneys will make sure that we put in as a contingency and the trust or wills that we write is something like a special needs trust. And a special needs trust is meant to protect a government benefit. If my nephew is autistic, intellectually developmental delayed, maybe cerebral palsy or Down syndrome, something that can allow them to have government benefits that is based on their need, their lack of assets. If they inherit money, they'll lose the government benefit. So we can build in trusts to allow money to go into a trust for them to supplement their needs and their government benefit while protecting that government benefit. So those are just some of the trusts we can put in wills.
So I have to ask this question. So at some point, I am sure you have illustrated this in writing or in a drawing. So do you draw a light bulb? Do you draw a light switch? How do you actually go about illustrating that?
I like bubbles because I'm not a very good drawer. So but you can go into PowerPoint or, something like that and use like the little icon shapey things and do like bubbles and with arrows to show things down and over and above. I wish I actually had it in front of me here on the desk to hold it up for us here on camera to show that my favorite illustrative device ever is I have a pen cup on my desk that I will take all of the pens out of and I will put this down and say, this is the concept of a trust. Again, it's a light switch. It will turn on if we need to, but the pens will connect to it as points and prongs on it to visually show how a trust will work. There's probably some better pictorial somewhere on my website though than that. Because no, I can't draw a light switch.
Well, we'll be sure to share a link to the website so people can check out some of these resources themselves. So let's get into something that really does get confusing for a lot of people, and that is power of attorney. Mm-hmm. So there's different types of power of attorney. If you can give an overview of what the different types are and when do they apply in different situations.
All right, well, let's do it. I have the first one that I always want to start with is the notion of a financial power of attorney. It is technically in Texas called a statutory durable power of attorney. I like to think of it as a business of life power of attorney because it is our ability to appoint someone to act as our agent for us for business of life types of transactions. So I need help paying my bills. I need you to talk to a third party on my behalf regarding an insurance claim. I need you to talk to my financial advisor for me because I'm laid up in the hospital recovering from major surgery and a decision needs to be made on something. You can act as my agent to do that, to represent me, step in my shoes and take care of those business of life things for me. Two real world examples that I always use when I talk about this power of attorney is how it's impacted my own life. As I am my husband's agent and he is mine. And prior to that, I had my best friend as an agent before I got married. But I had to use my husband's power of attorney to go and address registration on one of our vehicles. I'm not on the title. The little county clerk
Okay.
wouldn't talk to me about it. So I took this power of attorney with all of the insurance cards and everything I thought I would need, and was able to go in and get the registration issue that we were having resolved. My husband has used my power of attorney with the IRS to answer questions about a tax return that the IRS was convinced I had not filed, but surprisingly I did, y'all. Spoiler alert, because it was
Oh.
a joint tax return. So imagine that. I didn't file my tax return, but he did, and it was a joint tax return.
I didn't think the IRS ever messed up anything.
Right, exactly. So he was able to use that power of attorney, send it to the IRS, and work out that situation. So these can be really important tools. That one can be really important for us to have. And if we tug back in our notion of women and single women, this is our ability to pick that trusted advisor. Maybe it's our best friend, maybe it's our sister, maybe it's our cousin, to be able to step in and help us. If we're traveling a lot for business and our house floods, and I need you to start working with the insurance company to get something done, I want someone to do that. I want to have someone who can step in and help me with those things. The other thing about this document that I think is so important that people understand is the notion that it can become effective in two ways. A financial power
Right.
of attorney, it can become effective the moment we sign it, which is what I will typically recommend, because I'm going to want you to help me maybe tomorrow, even if I'm fine. The other way it becomes effective is if a doctor certifies that we are disabled or incapacitated. This is called a springing power of attorney. And, these are okay. I can understand how they appeal to some people who don't want to give up, oversight and control. They're worried about negative things happening and ramifications. Yet I tend to lean towards have it effective immediately, because if I were to have a tragic incident happen to me tomorrow, a car crash, a stroke, something that has taken my capacity away from me, I'm not sure that I want to have to try to wait for someone to get the doctor to say I can't do anything anymore, versus just equipping someone to step in who can immediately be dealing with bank accounts and paying the bills and taking care of that business of life things for me.
Is there a scenario where you may not be able to come up right at the top of your head, but a scenario where the springing might make sense for anybody in particular?
I can actually think of something where springing might come up into effect. And I tend to think of our younger generations when I think of springing. So, back to my own story, I intertwine everything I talk about with me personally. I did, when I was much younger than I am now, had my power of attorney be a springing power of attorney. And why did I do this at that point in time? Well, I was younger. I didn't have as many things in my life that might need to be managed or taken care of. If I had, something happened to me, I was married at that point in time. And even though it could have been effective with my spouse, I wanted it springing. It was a control thing for me. And I think that was okay, because the younger we are, the more, the less our mortality speaks to us, right?
Right.
So I think I was okay with that. So I tend to say in younger generations, I talk about the dangers of having it effective when you're disabled. But if a younger generation is adamant about that, after we talk through it, that's their choice to make. The older that we get, the stronger I suggest that we have it effective immediately, because we're open to more things happening in our life the older that we get.
Right. Okay, well, let's get into the next one. It's hard to say which of these may be more important. You may have your opinion, but let's talk about medical power of attorney and why that is so crucial.
Well, I think all of them are important. I think it's part of a toolkit that we all have. A medical power of attorney is our ability to appoint someone to make a medical decision when we cannot. And the key emphasis there is when we cannot. And so if I have that stroke tomorrow and I'm a single woman, I need someone who's going to step in, who's going to make medical decisions for me, a treatment plan, talk to the doctors. If I have to shift into a rehab or something like that, I need someone to do that. Texas Health and Safety Code gives us an order of priority if we did not have a medical power of attorney that says who the law would look at to make those medical decisions for us. But it is in some way having people on the same line. So kids, all my kids really serve on the same line there. Okay. And so they might have to have a unanimous decision to all decide to make this medical decision for me. Whereas it's probably much better for me to pick the person I want to make the decision,
Right.
define the order of it on there.
Perfect. And let's get into to me, one of the most confusing topics. And when you hear the term, we already talked about what a will is, but then you hear this term living will. What is a living will and how is it different from just a will? Where does this fit in?
I actually love that. I'm not a huge fan of living will. I will use it because people have heard that term, but
Right.
then I'll always say, look, in Texas, it is really called a directive to physicians, family, and surrogates. And I think we call it a living will because the concept behind it is that it's our end of life choice while we are living. And a will denotes when we're gone. I'm making that up. That may not be how it came to be, that words, but it seemed to make sense to me. But what this document really, really is all about is our ability to right now, while we're fully able and capable to make this choice to say, look, if I am terminal and I have less than 6 months to live, even with life-sustaining treatment, and I cannot communicate any longer, it is okay for me to be end of life care, hospice care, palliative care, comfort care. So keep me very comfortable, but let me die gently and naturally. Do not sustain my life. And in addition, it allows us to say if we have an irreversible condition, which is a condition that is not ever going to be eliminated or cured, I can now no longer communicate. And without life sustaining treatment, it's fatal. I'm giving permission to discontinue or not have life sustaining treatment, but let me go. Here's where I want to bring in the name Terri Schiavo for listeners. So Terri Schiavo was a woman. I cannot remember the state right now off the top of my head, but she had something happen to her and she was in an irreversible condition. She did not have one of these documents. And her husband said, we talked about these situations. We didn't want to be kept alive if nothing else can be done. If the doctors are saying there's not adequate brain activity anymore, we're brain dead, we cannot reverse this out. We didn't want to be on the machines and kept alive. Her family, her mother and father, felt differently, that she would want to be kept alive in the hopes that there would be a medical cure or a miracle or any of those things. And so we had a conflict here. And they ended up going to court over this. And it took many, many, many years to work through all of the court systems to come to a resolution that her support could be discontinued. And she did end up passing away. So we have that ability right now with a directive to physicians, a living will, to make that choice so that I can leave down the notion to my loved ones to say, look, if doctors are saying we cannot do anything else, please, I don't want to put you through the heartache. I'm giving you the permission to say goodbye to me. And I am directing you just to let me go comfortably and gently.
Very helpful. So I want to hit one more really key topic because again, just a point of confusion for many people is they think, well, if I've got beneficiary designations, I don't need a will, or I've got a will, so I don't need beneficiary designations. Please help us understand why it is so important to have those two items, your beneficiaries and your estate plan, coordinated to make sure it all fits together.
Well, you know that we need both of them.
Absolutely.
And we know that they need to coordinate, definitely. And why is that so important? Beneficiary designations are our opportunity to allow our assets to pass outside of probate, so it won't have to be pulled into our estate through a probate process. And it is a beautiful way to make that happen, to just say, look, I'm naming my spouse on these life insurance and retirement accounts. And it's great. I do it all the time. Where the alignment to me between them is so important is that wills cover much more. They don't cover the non-probate assets that can pass via beneficiary. They cover things like houses and cars and jewelry and books and all the things that our lives are surrounded with and fill our lives deeply. But we have life insurance. We might have minor children. And we want to make sure that we look at all of them as my pen cup and connect the spokes, connect the pens together. So if my ultimate goal is to leave everything in trust for my two kids until they are 25, then I should not name them as the beneficiary of my life insurance because that will go directly to them. If they are minors, they cannot control it until they're 18, which then opens up complicated notions of guardianship of the estate because parents are not natural guardians of their children's money. And so they have to go to court to get the ability to do that, to access life insurance. That's legal fees, it's complications, it's stress, it's a headache, it's all sorts of things that we can describe it as. So we need to actually look at them as combined elements. So if we sit down and do a will and an estate plan that says X, we want to make sure that the beneficiary designations align with X and say the same thing.
Well, that's one of the things that's so important. And I actually think I had you take a look at the document we prepare for clients every 2 years at least, where we're actually outlining, identifying who our clients' beneficiaries are, because that's something that's important. You know, things change, life happens, and we actually do it a little bit differently. Instead of just showing percentages, we actually break it down into dollar figures. So if you've got a $500,000 IRA, and your child Jane is going to get 250,000, and Joe's going to get 250,000. You might think twice about, if one of those, maybe they're not as good at managing money. So you need a process for reviewing this every couple of years to make sure that you understand what's going to happen and that you're comfortable with what's going to happen. And that's something that, I think all financial advisors should be doing. But if they're not, if either you're not working with a financial advisor or your financial advisor is not doing it, put a reminder in your phone every couple of years. Let me make sure I review my beneficiaries, make sure I've got beneficiaries, but make sure that it's still what I want.
I absolutely agree with that, Eric. I think that is a great strategy that you have there to work with your clients on that, because we find oftentimes on the probate side, when someone dies, that's the disconnect in what has happened. Because we'll have a spouse who's passed away 5 or 10 years ago, and now the second spouse is dying, and they never removed the other spouse as the beneficiary on their life insurance or 401k, and they didn't have any contingencies there either. And so now that's going into whatever contract terms might say it has to be, adding headache, stress to a family. And your document was really great. I really love a lot how you're doing that to make sure of that, because it's so important to take a look at all that stuff every couple of years, especially with what you said. And I'm going to say this: things might change as life goes on. You might, when you see those beneficiary designations in a couple of years, look at your life and go, that's not necessarily what needs to happen anymore. We might have a change. We might have a child who is divorcing, and we want to make sure that what we leave them if we die might be insulated from that divorce. We might have someone who has other issues in their life, drug addictions, gambling addictions. Maybe we have a child with special needs or a grandchild with special needs that we didn't have in our prior thought process. And now we're shifting to say, okay, we might need to do some modifications here.
Right. Well, thank you so much for the feedback. Yeah, it's just one of those important items. And again, I feel like I was spot on in having you on here to talk about some of these key concepts and just breaking it down into the basics and helping people understand and remove that fear. How can our audience connect with you, learn more about your services and what you do?
Well, they can certainly connect with me on my website, www.croupendownslaw.com, also on LinkedIn, and Instagram and Facebook. Check out Google, because there's some things on the Google as well about me, as we're trying to get more information out there. And regardless of whatever attorney anyone connects with, because it's all about who you connect with and who you want to work with. I just really want the message to be, please don't delay. Please take a look at this. It doesn't have to be a painful process. It can be something that, with the right person to help you, can be handled efficiently and maybe with a little bit of fun in it as we get to know each other.
Right. And again, please reach out to Chris. Again, she's got a lot of great content online, very educational information that, again, can help you move past those fears in order to actually take action. So yes, please, if you are interested in learning more about Chris, again, please reach out to her. If you would like to learn more about us at Blake Wealth Management, please visit our website at blakewealthmanagement.com. You can learn about our firm. Also, check out our articles page, where we actually have transcribed versions of our podcast episodes for those that may prefer reading rather than actually listening. And if you are a woman that is less than 5 years from retirement and have questions about how you can optimize your Social Security benefits, minimize your lifetime tax liability, and invest smarter, just click that Start Here button and you can review the process that we have set up to help you make an educated and informed decision about whether we are the right firm to help you navigate your retirement journey.
Thank you, Eric. Thank you, Chris. And thank you for listening today. Please like, follow, and share this podcast with your friends. Until next time, I'm Wendy McConnell.